Good afternoon to everybody. We start with the second session of this interesting conference. And the second session is devoted to intermediaries, regulation, and the market. I'm Professor Caggiano. I teach European Union law here at Roma Tre University. And I'm very pleased to have the honor to have the chair of this session. And I thank the organizer of the conference, especially Margherita Colangelo. We share the passion and the study of competition law. So for the time being, I would like to start this session and just giving the floor to Francesco Mezzanotte, who will talk about intermediaries, private law, and consumer protection. I will react after all, so that I hope to add some reflections to the one we wait from the speakers.
Thank you very much, Mr. President. Thanks to the organizer of this conference. So first of all, to Margherita Colangelo as scientific organizer. As anticipated, the topic has been assigned as dedicated to private law, implication of online intermediation, and specific focus on consumer protection. Just to clarify from the very beginning, I will not deal, though possibly connected with private law and consumer protection, with possible private enforcement of antitrust violation on online market. So consumer bringing lawsuit connected to harm they have suffered out of anti-competitive practices detected on those markets, nor I would consider the possible tortures or private law liabilities connected with the detection of unfair commercial practices on those markets. I would rather focus my attention on the private relationship that link together the part of the online intermediation, and in order to give the idea of the case from which I start, I would like to analyze in particular that hypothesis, standard hypothesis of a virtual marketplace, where we have a formal conclusion of a contract between a business and a consumer. So a business providing goods or services formally concludes a contract with a consumer through an online intermediary. So I hope to react to Professor Filistrucchi's analysis today, and as I understand, we are talking about as a two-sided transaction platform. I hope I got it correctly. So the point is that if we analyze the problem of consumer protection from a formal legal perspective in this case, the risk is to just focus on the formal legal contract, legal relationship and contractual relationship between the business and the consumer, and to try to solve with the principle that applies to this relationship issues of consumer protection. And just to provide an example, damages that may be caused to the consumer by the fact that he relies on false or misleading information that he has found and that has driven his consumption choices, or the fact that the business does not perform properly its obligation arising under the contract. The point is that what the economic analysis of two-sided markets show us is that here the business and consumer business-to-consumer contract is just the final moment of a wider and unitary, I would say, economic operation, as unitary is the market, those two-sided on which it is carried out. So the perspective is trying to give legal relevance and also in private law terms to the relationship that are beyond the formal one, business to consumer, and in particular the business to intermediary relationship on the one hand, and even more challenging, the consumer to intermediary relationship, always taking into account on both sides of the market instances, issues of of customer protection. And of course, I would like to stress from the very beginning that this is not just an issue that may be relevant, for example, for the law firm defending a business in a lawsuit, in a specific lawsuit against a consumer, or issues that are relevant for the lawyer or a consumer association defending a consumer in a specific lawsuit. If we associate also to private law standards possible regulatory, and we perceive private law standards also as possible regulatory tools, we understand that here we are talking about allocation of possible duties, liabilities, and eventually risk to all the parties involved in this transaction, and in particular involving in those risks the intermediary that economists tells us is the central focal part of this wider economic operation. So after all, it's something that relates to private law regulation of this kind of market, and I think this justifies my presence here today in a conference that, apart from my speech, is dedicated to antitrust and competition policy more in general. So I would start from a few observations on business to intermediary relationship, and then we would pass to consumer to intermediary relationship, which I think is more challenging. The main idea is that, starting from my case, the business to intermediary relationship from a lawyer does not formally create any particular issues, because this is a formal standard bilateral business contract, a business to business contract. This means that one could say issues of protection of the parties of the transaction can be just solved by applying general principle of contract law, or at least principle of bilateral business contract. The idea is that in the great majority of cases, we may have here a problem deriving from the fact that in concrete terms, the transaction may be connected and may be concluded by two parties having a huge asymmetry of bargaining power. So we can imagine a small or medium entrepreneur on the one hand providing goods or services, and a big player of the market, such as those running the online platform. This is an issue that has been raised also by a recent communication of the European Commission dedicated to a single market strategy for Europe. This is document published in May 2015, and I'm quoting one of the aspects that have been emphasized according to the role of the increasing role of online platform is connected to the concern for the strong bargaining power of the intermediary compared to that of their client, which may be reflected in their terms and conditions, particularly for small and medium enterprises. So, in a private perspective, this recalls a debate that is recently challenging European legal scholarship, and that deals with the problem of so-called asymmetric contract. So the question in general term is, when we have a business-to-business relationship and with a strong asymmetry of power between the parties, is it possible to protect the weaker business party according to principles that are formally set and dictated by the legislator in protection of the consumer? So applying consumer law principle to business contract. Here the point is highly debated, and I perfectly I understand different rationale of business-to-business protection to that of business-to-consumer protection, but I would say that here, in this particular market, we have elements that deserves also from a private law perspective further attention. And I refer to the analysis that is specifically based on the so-called price parity clauses, which have been analyzed and can be analyzed also from a private law perspective. I know they raise, and we have heard this morning, they raise important antitrust and competition issues. But of course, if we look at these clauses have been dealt by national case law, we can start from a very interesting case dealt by the Tribunal de Commerce de Paris in May 2015, where these clauses inserted by Expedia in his standard contract with a series of intermediated hotels were declared void, and this decision was based on the application of a parameter, that is the fact that these clauses caused an imbalance, a significant imbalance in the parties' rights and duties arising under the contract. And this is a typical standard parameter through which the consumer protection is carried out by the legislator, in particular if we think in terms of all the legislative, European legislative and national legislation of unfair contract term. And Margherita Colangelo was already mentioning today the recent national legislation, for example, in France, or the recent proposal by the DDL Concorrenza in Italy. The fact is that, and we understand the rationale of those legal intervention may be also focused on antitrust and competition issues, but the way through which this intervention is proposed is very similar to the approach of the unfair contract term, so we can see a kind of blacklisted clauses that cannot be inserted in those contracts. And I was not surprised to understand, and sorry if I got it wrong, but to understand that from an antitrust perspective, these were not very sound and coherent with the general principle of. But I would say that this reflects a kind of protection that is more static and resembles the one that is standardly applied in business-to-consumer protection. So this is just to stress a possible analysis of this business-to-intermediary relationship that goes beyond the simple application of business-to-business contract. Now, in order to respect time limit, I will pass to the, I was saying, more challenging part of my attempt to give legal relevance to this relationship that are carried out in two-sided market, and in particular taking into account the relationship between the consumer and the intermediary. And I was saying more challenging from a legal perspective, because here, starting from my case, we don't have any formal contract between the consumer and the intermediary. And if we, moreover, look at how the activity of the intermediary is generally presented, also through the terms and conditions that we can read on the website of the online intermediary, we tend to associate this activity as a mere neutral, passive one, the fact that the intermediary just collects, gather and present information that are provided by the business, so that in formal legal perspective, we can apply to this activity the standard principles that are relevant according to the e-commerce directive for the internet service provider, and as stated also in the recent communication of the Commission that I was already mentioning, as for today, the principle seems to be, and I'm quoting, that that of the e-commerce directive, that the internet intermediary service provider should not be liable for the content they transmit, store, or host, as long as they act in a strictly passive manner. And according to this document, it would be up to a further analysis and possible future intervention to test whether to require intermediaries to exercise greater responsibility and due diligence in the way they manage their network and system, explicitly to require them a duty of care. So here the point is that if we rely on those information and we just approach it formally, the risk is that the conclusion is there should be no way to elaborate and to carve out of this situation a kind of duty of care that is relevant in the legal relationship from the consumer to the intermediary. And plain and simple, this means that if, as a consumer, I buy a service online and, for example, I've suffered for an harm that is derived from the fact that I've based my consumption choices of false information or misleading information that I've found on the website, I do not have any legal cause of action against the intermediary. I do only have causes of action against the business. The idea that I would like to propose for in the final part of this presentation is that waiting for possible future harmonizing intervention of the European or national legislator, as legal interpreter, I think we do have ways to give somehow relevance to that to the specific relationship that is created in the two-sided transaction platform among the between the consumer and the intermediary, and to qualify it in formal, even contractual term, from which we may derive in specific cases where a specific contract is concluded between the consumer and the business through the web platform, a specific liability arising from this qualified relationship that characterize the performance delivered by the intermediary in terms of due diligence, in terms of duty of care, and in terms of duty of protection, which, and I will conclude on the consequence of this approach. And I would say that in order to arrive to this conclusion, is it not necessary to engage in an analysis of the reason that, for other aspects, is certainly relevant, but the recent interpretation of the e-commerce directive and the extensive interpretation of the liability of the internet service provider in cases of, for example, active hosting or content providing. The method that I would like through which I would like to approach the problem is different, and I would say that is the one that is at least implicitly supporting the famous Google Spain case. The fact of there being an internet service provider, this may be clear, but I explicit it, and the fact of there being an internet service provider does not preclude the fact that when other conditions set by the law are met, other series of liability autonomously may arise. So as in that case, the internet service provider liability coupled with the liability for the fact of being a controller of personal data, in this case, I don't see any particular problem in saying that, in general term, an internet service provider and the liability of the internet service provider may be matched with the one deriving from a formal contractual relationship that the intermediary engages with a consumer. In my opinion, the formal source of this qualified relationship in specific case of two-sided transaction platform is in the very moment where the consumer, by concluding the contract, formally accept the terms and conditions of the service provided by the intermediary. In formal legal sense, this is, in my opinion, the distinguishing feature from a legal perspective from two-sided transaction platform and two-sided non-transaction platform, even though we can do some further analysis of non-transaction platform. But in this case, with this formal acceptance, we have the entrance of the consumer in the sphere of activity regulated by the principle of the intermediary of the business itself. And in that moment, I would say that we have two conclusions. On the one hand, the consumer is, of course, subject to those principles and rules, but at the same time, it deserves the protection that the legal system can assure him as a voluntary user of that given service. And through this source, I would like to analyze the performance of the intermediary on the one hand and of the consumer on the other. And I would say that, first of all, if we analyze the performance of the intermediary, we can have argument to challenge the idea that through the consumer, this is really a neutral and passive activity, as is generally presented in the terms and condition of the intermediary themselves, where we basically read that they just provide a virtual marketplace where demand and supply can meet. There is, I would say, a positive performance of the intermediary, and this is clear, I think, if we start from an approach that is recently applied, often more frequently in applied consumer law, that is the result from behavioral or cognitive psychology. If we accept the fact that through cognitive biases or limited bounded rationality, the just the mere fact of gathering and collecting information may be, and the way through which information are presented, may be as important as the content of the information itself. This makes the activity of the Internet service provider in this specific case just per se not possible to define as mere passive or neutral. Here, moreover, the fact that the consumer, through the search engine of the intermediary itself, arrives to the point of concluding a contract, creates an even further qualified and legitimate reliance of the consumer in the performance given by the intermediary. And I would also consider the fact that this performance is somehow counterbalanced by a kind of performance that is provided by the consumer himself. Now, I'm not sure that in legal sense we can formally give result and relevance to the externalities that an economist, that is very clear for an economist, the fact that as an intermediary, the mere fact of there being a consumer on my web platform is an advantage, because I do need non-paying user on one side in order to attract paying user on the other side. And so the fact of just using that platform creates an network benefit, a positive network effect for the intermediary. I'm not sure we have tools to give legal relevance to that, but what I'm quite sure is that certainly in a legal realistic perspective, the fact that according to the principle of the legal system, but formally accepting the terms and conditions of the intermediary, the consumer delivers in accepting that contract his personal data, is information about consumption choices, ancillary information and evaluation of the goods or services that are brought through the web platform, and this information do have certainly a value also in a legal perspective as a possible counter-performance delivered by the consumer to the business. And third, I would say that if we talk about two-sided transaction platform, another relevant part is talking about monetary reward. And for example, if I look, and several other cases may be made, but if I look at the general terms and condition of Booking.com, and I read it under the heading of a free of charge clause, I read that in case of hotel services, accommodation providers, business, hotels, pays a commission, being a small percentage of the room price, to Booking.com after the guest has stayed and paid the accommodation. So I would say that for an economist here we have a passing on of resource, and the collector of those resources is the hotel, and the final recipient of this payment that comes from the consumer is the web platform. But even in a legal perspective, we do not need a broker to receive a formal payment by the two parties that are intermediated in order to qualify this performance as a typical contractual one of brokerage. And I would say that to this regard, it's interesting a judgment delivered by an opinion of the Tribunal du Commerce de Paris, which in a specific case of eBay, it was a case of violation of trademark through the web platform, but the rationale was that in that specific case, the provision of the e-commerce directive limiting the liability of the service provider were not applied, because of the fact that in that specific case where a transaction was carried on and there was a reward for the eBay deriving from that transaction, the argumentation of the court was, in this case, you are not an internet service provider. In this concrete case, you are acting like a broker, a mediator, and you are liable according to general principle of contract law. And in particular, in this case, it was a third-party liability against a third party, so it's a general application of principle of tort law. I can derive some corollary from this formal, qualified and even contractual kind of relationship that we can interpret as present between a consumer buying goods or services online and the intermediary. And I would say that specific corollaries are to be detected in a case-to-case analysis, but I can try to draw some formal conclusion. First of all, if we are looking for a possible source of the duty of care for the intermediary, still waiting for a possible future and harmonizing intervention of the national or European legislation, we do have room to ground a general duty of care for the intermediary where we can detect a specific concrete elements for a contractual relationship between the intermediary and the consumer. And this I try to explain why this is the case in my opinion with two-sided transaction platform, from which it derives that in terms of duty of care and protection for the information that are vehicled through the website, is it possible for the consumer to involve in the risk and the possible liabilities deriving from the harm that I suffer for having relied on those information? I can sue not just of course I'm oversimplifying, but as a main conclusion, I can sue not just the business who has provided those information, but also the intermediary. A second possible way of looking at this conclusion is the fact that once we formally accept that consumer to intermediary relationship may be qualified as a business to consumer relationship, we shall apply the general principle of consumer protection, and to this regard, among several other consequences, it would be relevant and interesting to analyze, according to the general minimum requirement of consumer protection, the terms and conditions that we find available online on the web platform. I'm not sure that all those clauses and in particular those limitations of liability that are explicitly stated in those forms will match the requirement of minimum consumer protection dictated by mandatory principle of the legal system. And third, a final possible question may be, given those duties of protection of the intermediary against the consumer, is it possible to involve the consumer, the intermediary, also in the direct risk of non-fulfillment by the business under the obligation rising from the business to consumer contract? So again, plain and simple, a business to consumer contract, the business does not perform his obligation properly. Is it possible for the consumer to sue not just the business but also the intermediary? I would say that even according to a broad interpretation of our case law on duties of contractual protection, it would be too far to arrive to state duty and to held a subject jointly liable with a third one for a non-performance that is explicitly and directly connected with a third-party liability. So this arrive to this point would be a bit difficult, even if we want to allocate in an extensive term the risk and the liability on the intermediary. But just to conclude, let me say that after all, this is a question of legislative policy and how we want to address the problem of how to allocate risk in intermediated market, given the role, the central role that intermediaries are assuming in this two-sided transaction. I found interesting to propose as a different model of possible way of addressing this problem the recent 2013 amendments of the Chinese consumer protection law, which in a first paragraph of Article 44 states that in case of non-fulfillment of the business, in my example, in this case, if the providers of online trading platform are unable to provide the true name and addresses and a valid contact methods for the vendors or service provider, consumer may also claim compensation for the provider of the online trading platform. But in more general term, as a conclusive norm, we read that where the providers of online trading platform clearly know or should have known, that is to say, duty of diligence, duty of care due by the intermediary in favor of the consumer. If the intermediary should have known that vendors or service provider harm the lawful rights and interests of the consumer through the platform, as it may the case of a non-fulfillment, the intermediary shall be jointly liable with the vendors or service provider. So clearly an inclusion of the internet service provider in the liabilities and in the risk arising from this kind of transaction. I'm not sure this can be law in action today in Europe. I'm not saying that this is necessarily going to be law in text or law in context tomorrow, but this is certainly a way to address the problem, and to address the problem in a kind of private law way of regulating the issues arising from two-sided market transaction. And so I thank you for the attention.
I would like to thank the speaker who was so brilliant in showing how complex are those relationships we are talking about, and how the business side of this triangle is important, but nevertheless the consumer protection has an impact at the same time. So this approach from the private law perspective to me was very interesting, especially if compared to what was in 2000 the e-commerce directive, and which still is there. I mean, it was never even if in 2010 there was an inquiry to the member states and other organizations to verify whether it should have been changed or updated. It's still there. So it's sure that the intermediaries play a different role than business or consumer. It's an autonomous concept. But as Francesco Mezzanotte said, in the Google judgment was clear that you can add to the liability of the intermediary, which is not on the content, as a matter of principle, is not on the content, could be added other kind of responsibilities. So I don't want to add more than that. I would ask to the floor whether there is someone, please.
Yes, I was wondering whether you consider a very intrusive approach as the Chinese. To me, it's intrusive. Approach as the Chinese one, as not something like that.
Yeah, thank you for the observation of which allows me to say that I'm not a supporter of the Chinese solution, and I'm not engaged by Chinese government to export kind of a rule in a kind of shopping of legislative principle. Just I would like to show that there is a way through which allocate certain risk in this market. Then notice and take down assumes the fact that that there is a kind of liability, so it would be a different kind of solution. But as for the topic of my intervention today, was still consider solved the major problem. Do we have legal grounds to ask something to the intermediary? Sorry if I'm oversimplifying probably the question. I don't know. We can evaluate whether it would be less intrusive or more intrusive, more effective or less effective to have a notice and take down rather than a joint liability as a kind of vicarious liability, because in this case the provider, the internet service provider, then is entitled to recover damages from the business. So this is a matter of interpretation, and I do not have an answer to that, but I would say that also if we arrive to the point of assessing a notice and takedown duty, we have already solved the problem of there being a liability or a sort of ground for a cause of action from the consumer to the intermediary. So I would, in this case, I would agree with you.
Well, because I was thinking that every time you talk to an ISP and you talk about PFK or something like that, they immediately answer it's too costly for us.
Yeah.
Find out a solution that is less costly. And probably a thing like a notice and takedown is a solution that I agree with you. I mean, it's a responsibility, but gives them an easy way out.
But I really thank you for the observation, because this is certainly better than I was able to describe. This is the fact that we are discussing about how to allocate a risk. So in this case, it's too costly for the intermediary. Okay, this risk is going to rest on the consumer, and we are choosing this. But what I wanted to emphasize with the Chinese case is that it's a legislative policy problem.
Other question?
No, to this question, I think the answer very simply from a policy point of view. I don't say this is what we want, but the solution is that of insurance. You insure yourself, intermediaries insure themselves against this kind of liability, and this means simply, very, very simply, that they are shifting the cost over to the consumers, because this means that they get a fee from the business, and within this fee, there is a very small percentage which is the insurance premium. So I think one can find some efficient systems of, I'm asking Francesco Mezzanotte, but this could be an efficient system for which you allocate damages which maybe are not so big as one could imagine, and therefore could be covered by insurance.
Yeah. As a question? I don't know, and this would lead us to investigate whether or not here we have a best risk or best insurer in the intermediary or in the single consumer. One could say in the consumer, because every time you are buying some services or good online, you are provided with the option of an insurance for those risks. So probably we can say that the best or the cheapest insurer of those risks is the consumer, and we stay with our set of liabilities, and we don't follow the Chinese example. But of course, I would say that the client in the Chinese environment of the insurance company is the online platform, while without such a rule, the client of the insurance company is the single consumer. I would say that.
Other questions? Okay. We have seen how this question could be also a policy question, and to allocate the cost of any solution is very important. So now we proceed with intervention of Sylvia Sekeli. It's very difficult to pronounce.
Don't worry.
For an
everyone.
Italian.
Yeah.
But she works for the European Commission, DG Competition, and the intervention is on the policy, voila, and the practice of the European Commission. The European Commission sector inquiry into e-commerce, because of course this is the other instrument to look at. That's it. It's provided by the competition law, European competition law, that the European Commission could inquire into a specific sector before giving an overall interpretation of the sector, of the evolution, and the solutions to be applied in that specific sectors. So And we are very interested in following your intervention. Please.
Thank you. Thank you. I'm really getting scared on these conferences because it's such a huge and vast debate and covers so many different issues that I'm kind of stressing more and more when going to these conferences about the sector inquiry. So I joined I was actually the first member of this task force that was created at the European Commission in the DG competition to do a sector inquiry into e-commerce, not more than that. That's for the time being not a final unit, it's a task force that is really dealing only with the sector inquiry. I will tell you a few words about what we are doing, what features, what issues we are trying to cover, what questions, and what is that we are trying to understand better, and what's the background to this sector inquiry. Now let's just start with the background. Just the trends. Again, the scales are not the same, but let's just compare for a minute the trends between online sales and offline sales from 2000 to 2014, the red line being the online sales trend. Here we have Eurostat figures about individuals who use internet. So out of those individuals who use the internet, how many are also purchasing online? And you can see the differences between the different member states. It's quite interesting. So you have between those countries that have most online shoppers, countries such as Denmark, Germany, Luxembourg, the Netherlands, the Nordic countries, Finland, Sweden, the UK, is a very important online shopper country. Italy is actually fairly low, if you can see in the middle. One more sentence to this. So this is the number of people who have internet and who also shop online. However, only 15% of these shop cross-border. So that shows also the importance of better understanding the problems that are not only related to online, but also and in particular to cross-border online sales. The digital single market and the Commission's strategy on the digital single market is really the background to the launch of the sector inquiry. It became a very big political priority for this Commission, and on the 6th of May this year, the whole Commission adopted a huge strategy. I don't know if you saw that strategy. It's a huge work of basically all the different directorates general, with proposals of different actions that are necessary to achieve a truly single digital market. The aim being, of course, a better access for both consumers and businesses to online goods and services across Europe, and to remove unjustified barriers. 16 targeted actions are covered by this digital single market strategy, which are nearly all regulatory actions. So, well, for the time being, many of them are just in terms of in the phase of assessment or public discussion, but many issues are already in the phase of legislative review. For instance, the review of the copyright regime, the thinking about a simplified VAT regimes, the review of parcel delivery rules, harmonization of parcel delivery rules, consumer protection rules, the public consultation on the role of platforms, of course, data protection rules, big data issues. I mean, all of those issues that you can have in mind are being heavily discussed and are part of the whole strategy that is the digital single market strategy. Now, these mainly legislative issues are complemented by the sector inquiry. The sector inquiry is completely different, so it's a competition law instrument. It's the DG Competition has the specific power to launch a sector inquiry to a specific sector of the industry. I will tell just a few words about the legal basis for this, but in any case, it's not about all these different barriers that do exist to online trade and to cross-border sales, which are more of legislative nature. For instance, the differences in VAT regimes or the different consumer protection rules or the parcel delivery problems. These are all important barriers to cross-border trade. However, there are other types of barriers which are company-erected barriers, which are the private types of barriers, and those can be dealt with under competition law. So the sector inquiry is focusing on those private barriers, which are the barriers that are created basically on the basis of agreements, mainly between the suppliers and mainly suppliers and retailers, just to simplify. The legal basis is, it was already mentioned today, indeed, there is this special power for the Commission to launch a sector inquiry on the basis of Article 17 of Regulation 1/2003, where the trend of trade between member states, the rigidity of prices or other circumstances suggest that there is basically a wide-scale problem in competition, not a company-specific problem. Then there can be an inquiry launched into that particular sector of the economy. That's not the first sector inquiry. You certainly know that there was already in 2005 a sector inquiry into the energy sector. There was a sector inquiry into financial services, and then in 2008, 2009 to pharmaceuticals. There must be, so as a motivation for the sector inquiry, there must be indications of such wide-scale problems in competition, and those we do have from many different sources. We have statistics that show that indeed more than 20% of wholesale and retail trade companies do acknowledge that they have in their relationships with their suppliers restrictions to sell abroad, and that's a problem for their retail activities. We also have indications that many consumers more than 10% are either redirected or the access to a specific website is refused. And we also have indications, mainly from a study by you, if I understand correctly, that indeed if such restrictions were removed, then the likelihood of engaging in cross-border e-commerce would be significantly higher. Just another figure there, if you take a look at the success rate of domestic orders, so when you want to buy something online from a national company, then the success rate of the transaction, including delivery, is 97%, whereas for cross-border orders, it's 48%. So it's much lower. The overall success rate from the very beginning of the transaction until delivery is below 50% in the case of cross-border orders. The targeted products and services, now it's a bit misleading because it's just a general Eurostat table about basically what people shop mainly online. So you can see clothes, travel and holiday accommodation, household goods, books, music, etc. But the sector inquiry is targeted on goods and digital content. It does not include services. Travel, hotel, etc. are not covered by the sector inquiry. It covers every type of goods. So it can be clothing, consumer electronics, other household goods, toys, children care, whatever, products, and digital content. Targeted undertakings, well, we already went out to more or less 2,500 companies with questionnaires. Most of them are retailers of goods and broadcasters. So retailers of goods, they are kind of nearly 2,000 in every member state. So we are trying really to cover all the member states. We have large companies and also SMEs. We go both to hybrid companies and to pure players. We sent a questionnaire also to marketplaces and to price comparison websites and to e-payment service providers. In the digital content, we went to the different content service providers. And we are still soon sending out a round of questions to manufacturers, well, less than retailers, but still a few hundreds of manufacturers. What types of restrictions are we trying to cover? Just in terms of broad categories. So we are trying to ask questions about cross-border sales, mainly the issue of passive sales, and on geo-blocking. I'll tell you a bit more about those. Restrictions to sell online, such as platform bans and different types of platform bans, and all types of pricing restrictions, mainly resale price maintenance and price MFN clauses. For that, we are really trying to ask ourselves the main questions about how e-commerce works and why. So we are really trying to understand the main trends and dynamics of those markets. We are asking questions about the turnovers online, offline, about how the distribution systems look like, whether they use more selective distribution than 10 years ago. If yes, why, on the basis of which criteria? Are these criteria more related to online trade or not, exclusive distribution, franchising, etc. Which channels do they use most? Do they use their own websites, marketplaces, brick and mortars? Do they use price comparison websites? We ask questions about geolocalization. How do they geolocalize? Do they geolocalize the user? If yes, on the basis of which data? And for which purpose? We ask questions about different marketplace bans and pricing agreements. We are asking a certain number of agreements so that we can really take a look at the actual contractual clauses and how do they look like. In digital content, well, the idea is the same. We're trying to better understand the business models and the justifications behind. We're trying to understand the different business models in terms of advertising or subscription-based or transactional, whatever. We are covering all types of content: films, fiction, movies, documentary, sports, news, music, children movies, etc. We are trying also to better understand what license rights they have, what territorial restrictions, where can they provide content, in which countries, on the basis of what, which content, are there catalog differences between member states, which there are, what are those differences in terms of catalog, and why. We are also trying to better understand the pricing features, on the basis of what main features do they price online content. So it's really very broad, and we do know that companies may not be very happy to fill out those questionnaires, but otherwise I think we're not able to ever answer basically all those questions that were mentioned today and that are really the focus of competition law today. For the case law, let me just mention two basic cases, which are the Pierre Fabre case and the Murphy judgment. The Pierre Fabre case, which applies for goods, which basically says that a contractual clause prohibiting de facto the internet as a method of marketing, at the very least has as its object the restriction of passive sales to end users located outside the contractual territory. So that's obviously a very important case, which tells us that if there is a de facto prohibition of internet sales, that's a by object restriction of competition. And for digital content, we already mentioned the Murphy case this morning briefly, which says that agreements which are aimed at partitioning national markets according to national borders must be regarded also as agreements whose object is to restrict competition. Now, well, this judgment, just to mention the core differences between potentially the pay TV case, for instance, that we are having today. This judgment is about satellite broadcasting of football. So it's different from several aspects. It's not online streaming, but it's satellite, so it's under the Satellite and Cable Directive. Where, well, that's a big difference, for instance, and it's also part of the questions that are raised when we review the Satellite Cable Directive, because in the Satellite Cable Directive there is this the country of origin principle, which is a huge difference as compared to online, because in satellite broadcasting, if the broadcaster has the authorization of the initial country for the broadcasting in the first country, then it's can freely then provide the content in other countries. If that could apply to online streaming, that would obviously be a huge step forward, for instance, for easier cross-border online streaming. The ongoing cases, well, they were partially already mentioned a lot. Pay TV case, of course, this is the statement of objections that went out last summer, the Amazon ebook case, and of course we have a number of cases which have already been mentioned, like the booking cases, with a significant coordination with the national competition authorities. In terms of timing, well, we're trying to have a preliminary report ready by mid-2016 for public consultation, and then a final report somewhere in the first half of 2017. This is my last slide, but if I still have a few minutes, I would like to come back to just a few questions which bring this whole thing a bit closer, and which also refer to some of the ideas that were mentioned this morning, if I have a few minutes after this slide. So the purpose is really to better understand how this whole e-commerce works, what are the basic, the main competition concerns of the different companies, the different players from the different angles, what are the market dynamics, what are the challenges companies face. We are trying to understand, because if there are widespread problems, widespread use of restrictions, it's probably that there is a reason behind. Now, what that reason is, in which scenario, and what the right answer should be to that problem, which is not necessarily the answer companies are giving to these problems today, but what answer should they be giving to these problems, is really, to understand this is one of the main goals of this inquiry. Obviously, depending on what we can find in the answers, the purpose is to provide guidance to businesses and also to national competition authorities through enforcement actions. There is also a clear idea to fine-tune the interpretation, not to rewrite the guidelines on verticals, but to fine-tune the interpretation, because the basic principles are there, but I think there are many issues where clearly national competition authorities do not agree between each other, they do not interpret in the same way, and it would certainly be very useful, as you already also mentioned this morning, to get some kind of guidance in terms of interpretation of the rules from the Commission. And clearly it is an initiative that is going hand in hand with the other initiatives for the same purpose of the digital single market. So the idea is really also to share the aggregate results that's come out from this inquiry with other policies for the purposes of legislation. So that's also one of the ideas that are kind of behind this sector inquiry. Now, if I just have a few more minutes, because it's very high level, or this is very high level, but just to show how important these questions are, also in relation to all the questions that were raised this morning and some others that haven't been mentioned. Let me just point on an ad hoc basis to a few cases and problems. For instance, in the Essex case, I don't know if you heard of the German case before the Bundeskartellamt about platform bans. So there is, of course, this huge question about whether platform bans as such should be considered as a by-object restriction, and on that the German competition authority declared in a kind of forbidden dictum that basically platform bans created a restriction to sell online, basically, and therefore should be considered as a by-object restriction. And I think it's really important also for these types of questions to see whether it's indeed should be considered by national competition authorities as a by-object restriction or not. For that, it's important that the sector inquiry comes up with some data, concrete, tangible data, as to how important platforms, and I'm talking now about marketplaces, so in the marketplace function, how important marketplaces are in terms of turnover and business for the retailers. And if we can show that, I don't know, for retailers, 90% of the online sales stem from marketplaces, then it's not the same approach. And I think competition law should not provide the same guidance as compared to a situation where we would understand that the retailers' own web shops or would potentially generate more than half of the revenues, and therefore there would be other very much viable channels to go online, and platforms should not be considered as the main instrument for online sales. That would certainly have a different outcome in terms of competition law assessment. We also heard a lot about, dual pricing. That wasn't mentioned this morning. For instance, the issue of dual pricing and RPM, which are sometimes a bit related. Dual pricing being when a manufacturer would sell the product at a different price if it's to be sold online, according to whether it's sold online or offline. Now, it's in principle a hardcore restriction to make purely on the basis of whether it's sold online or offline to make a price difference. However, it is also one of the questions for us to understand why companies do that. Is there what's behind? Are there free riding issues between online and offline? Because that's one of the justifications we can often hear also for RPM and for dual pricing, that yes, but we somehow have to deal with this problem that if we want to have our online shops survive, we need to deal somehow with these problems of cost differences, etc., and free riding from online to offline. But of course, free riding can also exist the other way around, from offline to online. It is also one of the questions we are trying to better understand, whether such free riding exists and what's behind the price interventions, whether it's via dual pricing or whether via direct intervention at the level of resale prices by the manufacturers, really to just better understand why are they doing this, and try to, with competition law tools, to react to that justification in the right and non-anti-competitive manner. Another issue, for instance, we are also trying to better understand how competition online, price competition works, because we discovered that many retailers use so-called spiders. I don't know if you heard of these softwares, basically, which are there to review competitors' prices on the basis of a few benchmark competitors. So they have a software, like Amazon, but everybody else. They have softwares that review prices that appear online in a continuous manner. And then many retailers give some, clear rules as to how to adjust prices on the basis of the prices by the benchmark dealers. So, for instance, always adjust to, 5% below the lowest price observed on the basis of the prices of those 5 benchmark dealers, or whatever rule. You can establish whatever you want. You can differentiate according to product categories, to promotion periods, to whatever. But it's automatized for many of the retailers now. And we actually, at the beginning of the inquiry, we had a number of meetings with economists, like also you, and we asked from some of them, we just asked this question: so how to deal with this problem? Because basically what we can observe is that it's a very close link to collusion, because what happens, they observe and then they adjust the prices on the basis of others' prices, and it was really interesting for us to hear that some of the economists were there, like, really enthusiastic. I mean, that's really the by the book perfect price competition. So we could never dream about anything more perfect in terms of price competition. So there is a competitor with a new price, and kind of immediately there is a reaction from the market, and the price erosion is immediate, and the price competition is perfect. And others who really warned us, like, pay attention, it's very dangerous. It's collusion. It's typically when the companies do not price on the basis of inherent cost or other internal criteria, but on the basis of others' prices, and that's what's collusion about. So I think there are no clear views on this, but at least we're trying to find out more about these behaviors and how to deal with those, and we're trying to have at least tangible information out as to the use of those software, and then to ask the question how to deal with those. Perhaps just a last one for an example which is fairly widespread, the use of selective distribution. We don't know yet, but it may be that selecting the criteria of selective distribution evolve, and that selective distribution would be used also as a tool for manufacturers to better control distribution, and not necessarily inherently for quality reasons, but also for price reasons. Now it's very difficult to make the difference between those two in certain cases, but it's certainly important for us also to understand how selective distribution is used. Is it still used for the initial purpose of non-price competition, so that other quality-related criteria can be introduced into the control of the distribution system by the manufacturers? Or is it more a kind of a protection of higher prices and protection against the price erosion online? To be seen, really. We are just asking all those questions and trying to have all the necessary information, but it's huge, so we'll see. Thank you.
So many suggestions, so many remarks. I would save some time giving directly to the floor.
Yes, just a question.
Yeah, so indeed, I think there are some issues which are fairly not new about since 2010, the guidelines, but where we see a bit more that perhaps the notions we use are not so clear cut, and we are asking questions about what companies consider as being active or passive sales. So we are kind of trying to understand how in practice the companies interpret the concept of, or they just simply use in their business the concept of passive and active sales, what that represents for them. And we're asking about very concrete measures they would take on selling online to see for us then what we could consider then as being passive or active. So we have some questions indeed precisely on that. On your second question, no, that wouldn't be a problem, to be very short. Our concern, at least at this stage, and that's why I also mentioned this question this morning. I intervened a bit on the price differences. So there is no other issue in the sector inquiry than the availability of passive sales. So it's not a matter of price. So what we're trying to see is whether a certain service or product is available from another country, independent of your nationality and location, whatever, within the EU. Whether once it is available, what exact price differences there would be, that's not covered by the inquiry. We're really trying to better understand how access is possible, but not targeted the prices.
Other questions?
You mentioned in passive sales, you mentioned Pierre Fabre. When you talked about selective distribution, you didn't cite the L'Oréal case, which instead went in the direction of saying that L'Oréal could somehow prevent sales of typically of its products online. So, I mean, would this mean that selective, the privilege that certain the cosmetic sector has in the field of selective distribution, you feel that is okay replicating this online?
And this is precisely a bit why we are trying to better understand these questions. We are asking very clearly about the selective distribution agreements, the criteria that are used in there, and trying to understand the mechanisms that are behind these criteria. Indeed, I think there is no... So, to answer your question, even as I said, so in the Pierre Fabre, what this decision says is that a de facto restriction to sell online is an object restriction. But it does not say about via which channels or how. So the issue for us is always whether it's a restriction as to whom the product can be sold. That's also what's written in the guidelines. Or it's a restriction as to how the product can be sold. And I think that's also reflected in the, so it's not contradicted at all by the Pierre Fabre judgment, because if you consider that to access customers, you need to go online in one way or another, then it's a matter of to whom you can sell, because if you cannot go online, there's a broad range of consumers who will not be able to reach. If, however, the question, and that's a question then L'Oréal or other types of question, if the question is rather as to how you sell your products, and it's a matter of quality or a matter of other criteria that you could also find offline. So there is an equivalence of offline and online in this regard that we are trying to maintain. But if it's a matter of how, and that those criteria could also be observed in the offline world, then it's a different issue, and it's not in the category of those hardcore restrictions which would limit your ability to reach certain customers.